Okay, thank you, Kelly. And welcome everyone. Thanks for joining me today. Wow, 100 participants. That's really exciting. Thank you for being here. Please, let me know in the chat if for whatever reason my audio goes out and you can't hear me, or you have any questions about anything that's presented. With that further ado, we'll get started. So again, the title of this presentation is, Progress Report, New Developments in the Law for Victims of Domestic Violence and an Update on Firearms. I'm just basically, this is the opportunity to run through some of the biggest changes and updates in the law regarding domestic violence and firearms, through statute and case law that we've seen over the past year. I'm not, in no way is this a definitive list. I'm sure there have been other important updates, and again, feel free to share them in the chat for everyone else. So yeah, I'm probably missed one or two, but these are the big ones that we have been paying attention to, and some of the things that we will continue to pay attention to over the months ahead. So again, I've broken sort of the topics into four main areas. First, legislative updates, going and discussing some of the major statutes that have been passed during the last year, a case law update, and then the third section is sort of stuff that we're looking for that's on the horizon. It hasn't been passed yet. It's still in committee or sort of theoretical, but it's something we are looking at, in terms of the future, and either maybe excited about it or concerned about it, and just something we would hope that you guys could also keep an eye on as well. And then finally, if we've depending on time, a discussion of trends that maybe you guys are seeing in your local offices. Pennsylvania is a pretty big state. We have, I think, 69 counties, and they all do things a little bit differently. So, if you guys are seeing, some of the northwestern counties, you guys are seeing something interesting that maybe the counties in the southeast near Philly or Montgomery are not seeing, or that might come this way in the near future, that would be a great opportunity to share and discuss. So first, legislative updates. The first one, I guess, I think a lot of you guys will be, aware of a lot of these changes. The first being Act 100 of 2019. So this is the sextortion bill. This was PCAR's big thing last year, and they deserve a lot of credit for getting this passed. So essentially, now the crime of sexual extortion, which is, basically, requiring or coercing someone to take action through threat of, dissemination of private images or information, is now a criminal offense. So that's a big change, and something that is a long time coming here in Pennsylvania. Act 1 of 2020, though, is arguably even more important. So this one, this is the quote unquote Buyer Beware Act, which significantly increases penalties for human traffickers and patrons of human trafficking victims. So that's where the buyer beware comes in. So this is, we were happy to see this one, where in that, it's criminalizing the traffickers and Johns, or, the customers, rather than further victimizing the individuals who are being trafficked. So, that's always the risk of, laws that are trying to combat human trafficking and prostitution, is that the victims will be the ones sort of swept up and criminalized. But, we haven't seen that happen quite yet. But again, it's quite new. It just was enacted on May 8th, 2020. So technically, it's not even effective yet. It'll be effective in 60 days from May 8th. So around July 8th, that will be when the law is, enforceable. Act 18 of 2020, this was another big one, and another just recently passed during, COVID-19. So now in Pennsylvania, you cannot get a marriage license if you are under the age of 18. There are no longer any exceptions for, essentially parental consent or judicial bypass. You have to be 18 or older in order to get married in Pennsylvania. I don't know what your various legal offices or programs, what position they took. I think we ended up, for various reasons, remaining neutral on the bill, but many of us were nevertheless excited to see this passed, because we did, understand that the various exceptions for underage marriage created a lot of opportunities for trafficking and victimization. So I know that there are people that are trying to get married at 16, 17 for very normal reasons, but I think this Act 18, it certainly does much more good than harm. Then, Act 32 of 2020. We're also interested in this one. This, brings strangulation more, I guess how to put it, more fully in line with the Criminal and Domestic Relations Code. So I'm sure all you are aware that strangulation has been a criminal offense for a couple of years now, at least, probably 2 or 3 years now. But now it's more entwined with the rest of the criminal code, and at least in my opinion, the even better is it's now a crime of violence. It's a quote-unquote crime of violence and an offense to be considered under 23 PACS 5329. So it's one of those 5329 offenses, which now will have to be listed on that criminal record or abuse history affidavit. And I understand that, at least when I was in practice, I was not seeing a whole lot of convictions for it. It seemed like it was more often than not essentially being used as a sort of a carrot or a stick to induce plea bargains to a lesser offense, such as simple assault. But I understand now that it's actually being more and more aggressively prosecuted. So that's another big help to victims of domestic violence, and ultimately, helping secure the safety of victims, and secure the sanctions and punishments for abusers. And then this, again, I think this is probably something most of you did not miss, but I wanted to put it on there because I almost did, and I just wanted to make sure everyone was fully aware of it. So the reason this sort of popped up again is this was not a statute change. So the statutory change which created this was, I think, in 2016, but they actually just changed the rules of civil procedure to create the necessary forms and processes to allow this to actually work. So there is now what's called a personal injury divorce, where the consent of a party to a divorce is presumed where that party has been convicted, pled guilty, or nolo contendere, or entered into ARD for a personal injury crime against the other party. And those offenses are defined. They are more or less, I can provide you with the exhaustive list if anyone's interested, but basically, simple assault, aggravated assault, I believe attempted homicide, strangulation, I believe is also one of them. So basically, If you have you're convicted or pled guilty of an assaultive offense against your spouse, then if your spouse tries to get a divorce, there's no more of the sort of the rigmarole over whether you are going to consent after the 90-day cooling off period happens or not. The consent is presumed. There are, as always in the law, ways to overcome that presumption. I haven't seen anyone successfully litigate that. And obviously, the divorce itself does not preclude either party from seeking a bifurcation for the other matters such as equitable distribution of marital property. But this is a big change, and we were glad to see the AOPC really sort of bring it to a close in allowing the victims who are trying to get a divorce, trying to get away from their abuser, creating an opportunity for them to get that done that doesn't involve them either trying to finagle the consent of the other party, the consent of their abuser, or waiting through that date of the period of separation, 1 year now, and even then possibly having to deal with them signing and filling out the counter affidavit and making it more difficult for them to obtain the divorce. So again, I think this is something we will be seeing more of, and it's certainly something that we should be aware of and be prepared to, I guess, use for many of our clients. All right, case law updates. Okay, so I actually think I put the two most important ones first rather than saving them for last. It is what it is. The first is Courtney v. Courtney, 205 A 3rd 318 PA Super 2019. Basically, which the holding is the failure to prove allegations by a preponderance of the evidence shall not by itself result in a finding of bad faith. I know this is sort of obvious, and take it for granted. I mean, if you see, I wrote on this slide, see also 23 PACS section 6117. The holding is literally, is the quote of the statute. But it's nevertheless important. This is the first case that we've really had, really significant case on what entails bad faith in terms of PFA cases. So in this case, the victim, filed for a PFA. There was, at least at one point, a withdrawal and then a refiling. They had the hearing. The victim, unfortunately lost at the hearing, and at that point the defendant asked for sanctions and attorney's fees and got them. The judge awarded them attorney's fees and sanctioned the victim, the plaintiff. And fortunately the Superior Court said no, that's not how that works. Just because the victim loses at the PFA trial does not mean that they acted in bad faith. Failure to meet the burden of the preponderance of the evidence is not bad faith. So I guess over the next couple of years, maybe we'll see more examples of maybe what does constitute bad faith. But at least we now have a solid precedent that should prevent many of our clients from being hit or bludgeoned by the PFA statute, or feel like they are being hesitant to file a PFA because they're the abuser says, well, if you file this, I'm going to seek attorney's fees and everything else. So hopefully that will help things in terms of our clients. This other one, CHL versus WDL, I expect again, many of you were aware of this case. So again, the holding is that a PFA court does not need to conduct a best interest analysis to award temporary custody as a form of relief under Section 6108 of the PFA Act. So when a judge is granting a plaintiff, temporary physical custody as a form of relief under 6108, they don't have to do that that analysis, because the PFA is essentially it's a safety measure. This is not about necessarily what is ultimately in the long-term best interest of the child. This is to protect the plaintiff and the children from danger from an abusive individual. So again, clarifies that while a domestic violence emergency is still pending, a PFA may alter a pre-existing custody order or remand for clarification to avoid conflict if need be. But so again, I don't think this is necessarily groundbreaking for many of you. Many of our practices, I think it was a given that if you've got a custody order already in place, the PFA, if one party obtained a PFA over the other, the PFA might very well impose a custody order that would at least temporarily supersede the prior existing custody order. And if no custody order existed, it would certainly, one would be in effect until the defendant, or the plaintiff filed, a custody complaint to get that ball rolling. And at which point, when a custody order was entered after the PFA, it would of course have primacy. So I don't think this is that groundbreaking, but again, the fact that it clarifies about what it needs, the judge does not need to do the full 16-factor analysis, is an important clarification that we're happy to see. And then I also urge you guys to take a look at this case, because it really has some great language related to the coercive control and the nature of abuse and its effect on children. So it's dicta. It's not it's not binding, but it's really great stuff. It's really nice to see the court beginning to recognize that stuff and take note of it. So it's nothing groundbreaking legally, has no real precedential effect, but maybe we'll start to see more of that in the future. All right. Again, so then HMH on behalf of minor LMH versus DJG. This was an interesting case. Essentially, the abuser, it was it theoretically could have been either a PFA or an SBPO. The victim was sexually abused or assaulted by their first cousin. So they ended up seeking the PFA. The defense initially tried to argue that couldn't get a PFA because didn't have standing, that this wasn't a relationship, this wasn't a family or household relationship, and the court disagrees. So first cousins is within the sort of the degrees of consanguinity that under the definition of family. So if the first cousin is the abuser, the victim has can seek the PFA, even if they it's so that's again probably something that I think was probably taken for granted by many people, but that was certainly not the case before this decision came down. So that was a pretty significant change. And then KBV Tinsley, the defendant's behavior, which included incessant texts and phone calls, public verbal abuse, stabbing an air mattress in front of the plaintiff, and physically accosting her in a parking lot, supported the entry of a PFA order. Again, I perhaps nothing too groundbreaking, but I think a useful case in further establishing the sorts of circumstances that can create, that can establish a PFA order. I know that, in many cases, we struggle with obtaining relief for victims where maybe there was physical abuse in the past, but it was very attenuated. It was maybe a year or two ago, so it wasn't the inciting incident, or else in some cases there's never any sort of physical contact, and it's merely this sort of series of threatening actions and conduct. So I think this is a great case in terms of illustrating the sorts of actions and conduct that can create that, the course of conduct grounds for a PFA. All right. This was an interesting one. So KNB versus MD. This is an SVPO case, actually, but arguably could be applied to the PFA statute as well. Basically, the main holding is that SVPOs have there's a 6-year statute of limitations. So technically, if the conduct can have taken place, 6 years prior to filing and still, or within 6 years of the filing and still establish or be sufficient grounds to, sustain a SVPO, because basically SVPOs fall under that catch-all provision under Title 42. And likewise, a credible assertion of sexual assault is sufficient for the entry of an SVPO. Apologize for the typo. Again, just establishing that this is, again, it's a preponderance of the evidence standard. It's not clear and convincing. It just needs to be a credible assertion. So again, decisions that should be obvious, but were very necessary to sort of straighten out the law and create some clarity and better protection for victims. And in this case, HR and CAR versus CP and JM, appeal of CP. This was an interesting case. This basically involves it's a grandparents' rights case, essentially, where the grandparents had primary physical custody. Father, who was the son-in-law, was trying to gain more custody, and unsuccessfully. He'd had a long time. He's a long-term drug user, and when he was filing the most recent time, he said, "Oh, you can't drug test me anymore, basically, because I have a medical marijuana card, and that if I'm using marijuana, that can't be held against me in terms of the custody action." And the court disagrees. The Medical Marijuana Act does not preclude the trial court preclude the trial court from making relevant findings concerning the effect of marijuana use, whether medical or recreational, on a parent's ability to care for his or her child. So I think this could be a double-edged sword for many of our clients. I think it could both help, but also potentially hurt. Because I know that there are, many victims that use and who need medical marijuana. So this is something to be to consider, that the fact that they are a legal user of marijuana, they have a medical marijuana ID card, will not necessarily keep the court from determining that it somehow might affect negatively their ability to take care of their child. So that could be something that we just need to continue to watch out for. Hopefully I will not happen in many cases. I mean, in this case in particular, it seemed like the medical marijuana ID card was essentially trying to justify his previously irresponsible behavior or an illegal use of marijuana. It being what it is, but I can see that this could, like I said, be a double-edged sword. So just something to keep in mind and be aware of, over the next, months and years. Does anybody have any questions yet? I'm not seeing anything in the Zoom chat.
MacKenzie, while people type in any questions they may have at this point, I'm going to launch the first of the 2 CLE question poll boxes. If you're an attorney requesting CLE credit for your participation today, please respond to the question. You'll have 1 minute to do so. Thanks, MacKenzie. You're free to continue.
No problem. Oh. Let's see.
You could just click off of it.
Okay. Can I didn't want to end the poll. Okay. All
yeah.
Right.
Thanks.
All right. Shall I share results, I guess? Thanks, everyone. Okay. All right. Great. So, all right. And then on the horizon. So these are, like I said, again, things that we are looking out for as potentially good things or bad things in the near future. So first, SB 868 is Caden's Law. I'm sure everyone knows the tragic story of Caden Mancuso, who was murdered by her father, and her mother's been a tireless advocate for some sort of change to the custody statute, which takes into basically, which requires the courts to take into more account the abusive past of of the abuser. So the violent past of the abuser. So I think in some cases we've seen, I know when I was in practice, the judges would often sort of brush off abuse or other bad behavior if they didn't feel like it affected the child. So, you have a PFA against him, but he never attacked the child. So I'm not really I don't really think that that's that relevant. Or, he had a DUI or a, some other 5329 offense. Oh, well, that happened before the child was born. That's not really relevant. So that's it's that sort of thinking that Caden's Law is trying to remedy. And I think it's still very much in the early stages. There was an initial draft which PCADV was examining and working on with Senator Sanestiero, but it was admittedly a little bit of a mess. I think it was trying to please too many people. But the most recent draft, which came out roughly 2 to 3 weeks ago, I will say looks a lot more promising. I don't know whether it will be successful, whether it will ultimately, pass the Senate and the House and then be signed into law by the governor. But it is, I think, an important step in the right direction, an important attempt to remedy some of these, the situation where an individual's abusive and pattern of abuse is not taken into sufficient consideration and requires the court, when there is a history of violence and abuse, to right from the get-go impose some significant safety protections for the child, and only lift them once the defendant, once the abuser has sufficiently shown that they have taken the steps to either, whether it's batter's intervention or some other form of counseling to keep that move beyond that. And it also does one other important thing. I think there's been the trying to think of the word. There's sort of this talk of the other thing it does. Sorry, I should say is that it's keeps so that if a parent is, they won't be, it will not be held against them if they take certain steps, such as keeping the child away from the abuser, or warning the child about the abuser, or saying negative things about them, if they're acting to protect the child. And it really sort of hammers that point home. I think that there's this the idea that parents are and there's the syndrome of trying to turn the child against the other parent. I think the science has shown that that's not a real thing. Yes, there are parents that do try to turn the child against the other parent, but that's few and far between. It's not based on a mental condition. So I think that Cadence Law will try to remedy that, which we're happy to see. And again, I think there was fortunately there's been this sort of tendency or history where often the victim of significant abuse would have to quote unquote play nice with their abuser, or else they face losing custody in many cases. I mean, if I think they found that if the abuser sought custody, they were going to be successful 70% of the time. So I might, if I have this is wrong, I apologize, but this is Cadence Law will hopefully mitigate that to a certain extent. The next, Marcy's Law, again, I'm sure we all know about that, the Victims' Rights Constitutional Amendment. The reason I was just put it up there is something on the horizon is we should, in the next couple of months, I would expect we will have some sort of decision from the courts as to the constitutionality of the Marcy's Law Amendment, the constitutionality of the process, and whether that will be an amendment to the Constitution. I'm of sort of two minds about it myself, I'll admit, but it'll be just something we'll have to look out for, wait and see as to what happens. But so just keep an eye out for Marcy's Law. Finally, or not finally, sorry, HB 437 is a custody contempt bill. So this is interesting. So basically what this does is it expressly permits makeup time as a remedy for contempt. So now if if a party is held in contempt for failure to return or withholding the child from the other party, and they're found in contempt, it was a willful, wrongful act, then the party who lost time because of the bad conduct can have makeup time. I know that this is, again, I think for many of us this might seem to be a somewhat strange idea, because I think a lot of courts and conciliators are doing this anyway. But I think we all had to do, I'm sure, as everyone knows, we always had to do the petition for modification with the petition for contempt, because obviously the Supreme Court ruled a few years ago that a petition for contempt in and of it by itself you couldn't give makeup time, because it was essentially a quote unquote modification, and you couldn't have that modification without providing the other party with notice that it might happen. So that's why we were all having to file petitions for modification with our petitions for contempt if we wanted that form of relief. So this will make it so that's no longer necessary. You will just file a petition for contempt and list makeup time as your requested relief. I'll admit, in our office, we had some significant back and forth as to the wisdom of the statute, and at this point we're actually sort of tentatively optimistic about it. Basically, the idea being, you know, if a petition for modification was filed, you know, it opened the door wide, you know, wide open for any sort of custody change. You know, not just make up time. I mean, the judge could, you know, totally, you know, refit the custody situation. The party, you know, filing for contempt could have had primary physical custody. They're trying to get makeup time. They go to the hearing, and since modification is on the table, the judge could, you know, the judge could totally switch the custody situation around such that the party in contempt initially will actually, you know, will leave court with primary physical custody. So it's something you know, I rarely saw, but it is something that it definitely happened if, especially when you had one party, the abusive party generally, who would, you know, continuously withhold custody, and the other party was, you know, filing lots of petitions and everything else, and the judge would say, you know, I'm sick of this. I'm going to do something different with custody. So this will, you know, hopefully keep that from, you know, happening, because essentially only the time missed can be awarded as makeup time. The judge, you know, can't do any drastic modifications to custody through a contempt sanction. So if, you know, mom missed 2 weeks, she gets 2 weeks. The judge can't, you know, change it from, you know, 50-50 to mom only having every other weekend or dad only having every other weekend. That's not an available remedy. So I think, you know, because it sort of keeps things from swinging too far in either direction, you know, that's sort of why we are tentatively optimistic about, you know, what it will do for, you know, or its benefits for victims. And then the last thing I'm looking at, and I don't know if anybody else is looking at these, the Second Amendment, the Second Amendment ordinances. I know that there have been a couple of counties, I think, or communities. I think is Fulton County maybe did it, maybe at one or two communities there. And I think in the Northwest, there have been a couple of communities that have done this, but basically they are saying that the sheriff's, law enforcement, they do not have to, not only do they not have to abide by the, you know, firearms relinquishments provisions by, you know, under, you know, Title 23 pursuant to the PFA statute or Title 18, but in fact, if they, you know, enforce this, then they are breaking the law. I have not seen, you know, I've not looked closely at these, but it's pretty odd. It's pretty troubling. I have not seen anyone prosecuted for violating a Second Amendment ordinance. I highly doubt the criminal prosecution would succeed. Even if they were initially convicted, I doubt it would survive on appeal. But it is sort of troubling and something we are keeping an eye out on just here at PCADV, just because of its potential, you know, impact on Act 79 and the PFA Act. Any questions, thoughts from anybody? Kelly, do you want to put out the next poll question?
Sure, I can do that. Let me get it up here. Okay, I am going to go ahead and launch the second poll question for attorneys requesting CLE credit for your participation in the webinar today. Please respond to it right now. And MacKenzie, if you just X out of it at the top of your poll box, it'll still leave it up, so I can leave it up for a minute.
Okay.
Thank you.
No problem. All right. And then, you know, I'd like to use the last 10 or 15 minutes or so, if possible, for, you discussion of trends that you guys are seeing and interested in terms of firearms or laws pertaining to to victims of domestic violence or victims of sexual assault or intimidation for that matter. If you're seeing anything in your work that you think is particularly interesting and noteworthy, please share it, because I think all of us could really get some value out of that. All right, well, anyone? I'm questioning how actively participating everyone is now. So I mean, because that's what we're seeing. Like I said, though I don't think I have captured everything that's going on, that's new and happening in the courts and the legislature. So please, if you've seen something that I missed that you think, okay, yep, strangulation quite a few times in Lycoming. Great, thanks. So Lindsay, I guess if you want to respond in chat again, and you're seeing them being convicted of that offense, or is it sort of they're being charged and then they plead down? Okay. Okay, Beaver County courts still refuse to address custody and PFAs. Angela, I know that's frustrating. And actually, you were the one that first shared that case with me. So, yeah, I guess that will just be another, something we just continue to have to do systems advocacy on. I don't, especially you would think that case would have really hammered it home that they can and in many cases should deal with custody as part of the PFA. Again, it's not custody per se. It's just it's a safety precaution. So yeah, I don't see how they're not aware of the fact that not issuing a sort of a custody order will put the victim in danger.
MacKenzie,
okay.
Sorry, yeah. I don't know if you saw Lindsay's second response, but she said, I've seen several charges, and I know in at least 2 cases there were convictions.
Okay, that's great. Thank you, Lindsay. Thank you. Joseph, okay, the voluntary relinquishment of firearms. Okay, yeah. This is a tricky one. I don't. And you're right, it's sort of frustrating. If it's a voluntary relinquishment, so they say, so I guess, Joseph, so they've either the relinquishment is either pursuant to an agreement or there was a hearing and a judge ordered the relinquishment. Yeah, I think Barbara has said as a firearms declaration form the defendants must sign. What I think she, that's right on. What I've seen been most successful is essentially when they say, I don't have any firearms, they're ordered to relinquish firearms and they say, I don't have any, basically what's been most successful is have them sign an affidavit so that if it turns out that they are, lied and, did not relinquish their firearms as they were required to, they're now facing, failure to relinquish charges, potentially federal charges, and also, false statements to law enforcement. So, it ups the potential criminal penalty that they are facing. But yes, they are prohibited, unfortunately, unless there is an ICC, violation for an ICC arrest. They don't have the option to, to search the premises. I mean, unless they have a search yeah, search warrant. Yeah, I mean, I think problem is you've lied in the client's stead. That is an unfortunate. We have seen that a couple of times, which is, you know, a tragic circumstance. That being said, we have actually, there have been a couple of cases where the failure to relinquish was discovered by, you know, basically they applied for a hunting license, or they were found out, they were, you know, seen hunting by, you know, the wildlife officer. You know, maybe they were, you know, they were quote unquote poaching, and that they were able to be then prosecuted for that failure to relinquish that way. But yeah, I mean, I don't, unfortunately, absent a, you know, if the defendant, or sorry, if the plaintiff, you know, flat out, you know, knows that they have the firearms and they've failed to relinquish them, you know, I think possibly, you know, again, I'm sort of thinking off the top of my head, but I can, you know, I think if they can, you know, try to push for the ICC, which if they're, you know, being arrested and charged with the ICC, the police would be able to do a search incident to an arrest. They could also, again, you know, say, oh, you know, they failed to relinquish, and the police, you know, upon, you know, credible you know, averment from that plaintiff, could seek to try to get a search warrant, and search the premise, you know, search the home under those circumstances. But again, you know, I know that there was some discussion last year and early this year about, you know, creating a broader sort of search exception or warrantless search exception with the PFAs. We just, in our office, we were concerned that that would be more harmful than beneficial, especially to victims in underserved populations. So that's where sort of our office came down with that. But I do think, you know, you have, you know, certain, like, you know, the options that we were discussing in terms of, you know, doing the best to have the firearms discovered ahead of time. But I also think there are many options in which to, you know, punish that behavior severely. So, you know, ideally the violation is not discovered due to the homicide of the victim. That, you know, that's the worst case scenario. But you know, I think one key step that can be taken is that when this failure to relinquish is discovered, that it be prosecuted to the full extent of the law. You know, not only the failure to relinquish itself, but the lying to law enforcement. And I think really one thing we're looking at in the near future, at least once we get out of COVID-19 isolation, is working more with the U.S. Attorney's Office. Actually, the U.S. Attorney's Office for the Western District has been very interested in sort of beefing up the prosecution of, you know, these sort of the failure to relinquish pursuant to a PFA or a misdemeanor crime and domestic violence, because it's not only a state offense but a federal offense, and it has much more significant penalties. So I think that could be, you know, another avenue that we can continue to explore, is that if the penalties are so severe for lying on the relinquishment form, then hopefully that will, you know, create some incentive, you know, for individuals to stop doing that. Any other questions, comments, trends that we're seeing?
MacKenzie, I'm not seeing. Did anybody have anything else?
No, not seeing anybody else. Okay. Well, thank you again.
Yeah, thank you for being here with us today. We appreciate you taking the time to join us and share this information with us. It's been very helpful.
Okay, great. So that's, my contact information below. The particular attention to the 833-727-2335. That's our PA Safe Law number. That's our VOCA funded project through PCADV, the confidential legal helpline. Again, I expect that no one on this call will be, sending anybody to us probably, but I do hope that we'll all be in touch, because we will definitely send people to you if we know you're available. So we, thank you for all the work you all are doing, and thank you for participating in this webinar. It's been great, and thanks for some great questions and comments.
Great. Thanks, MacKenzie. Everybody have a great afternoon.
Thank you. Have a great day.